Hi, very good morning. This is another interesting Supreme Court judgment. Citation is Glencore International AG versus Sri Ganesh Metals. Arbitration and Conciliation Act. Dispute is under Arbitration and Conciliation Act. Issue before the Supreme Court was if contract is not signed by one of the parties, will the arbitration agreement under the contract is enforceable in law? That is the question. Facts of the case: GI is a Swiss company, that is Glencore International. Hereafter, I will call it as GI. She Ganesh Metals, I will call it as SGM. So, GI is a Swiss company, SGM is a Indian partnership concern. SGM was purchasing zinc metal from GI under contracts. Previously, it was 4 contracts they were purchasing, and there were no disputes. The contracts contained an arbitration clause which stated that dispute should be resolved under rules of London international arbitration, and seat of arbitration will be London. In those 4 contracts, then the parties proposed to enter into a subsequent contract. This is the 5th contract for purchase of 6,000 metric tons of zinc metal. The terms and modalities of the contract was sought to be worked out. SGM, that is the purchaser, suggested some change in the provisional price. The terms also required a standby letter of credit to be opened for the purchasers. The same was accepted by GI, the Swiss company. Then GI forwarded the contract duly signed by it to SGM for its signature. This contract also contained an arbitration agreement similar to the previous contracts which I read just now, London International Arbitration. SGM did not affix its signature on the contract. Then 2,000 metric tons of zinc metal supplied under this contract was accepted by SGM. Totally 6,000 metric tons, 2,000 out of which 2,000 metric tons were supplied by GI, and it was accepted by SGM. On behalf of SGM, HDFC Bank opened 2 standby letters of credit. There were some disputes, I am not giving it in detail, some disputes were there. Emails were exchanged between the parties. GI called upon SGM to comply with its contractual obligations. SGM assured that it will not commit any default in the performance of the contract and promised that everything will be in line with the contract. Since SGM did not adhere to the contract, the letters of credit were encashed by GI. The balance amount under the letters of credit were also retained by GI. GI also said that it would like to continue the relationship. I am having a good relationship with you. I will try to continue the relationship, provided the issues are resolved quickly, and was ready to complete the delivery of balance quantity. Then SGM, it filed a civil suit to declare the invocation of standby letters of credit by GI as null and void, because GI has encashed the standby letters of credit. It wanted to get it declared as null and void to pass a decree for recovery. The amount which has been recovered by them, they wanted to get it back. 3. Permanently injunct GI from invoking the letters of credit. That is the 3rd prayer. And 4th prayer, injunct HDFC Bank from releasing any payment. So a civil suit was filed before the Delhi High Court, making the following prayers. These 4 prayers were made. GI filed an interim application before the Delhi High Court to refer the matter to arbitration in view of the arbitration clause. The single judge of the High Court, Delhi High Court, rejected it on the ground that no concluded contract came into existence. The Delhi High Court said the terms and conditions were not accepted, signed, and stamped by SGM. So no concluded contract came into existence. The court held that the exchange of emails did not lead to inference that SGM either expressly or impliedly agreed to the terms and conditions. This is what the court said, reasoning of that court. Then GI filed an appeal against this order of the Delhi High Court before the division bench. The division bench also dismissed. I am not giving the full reasons. Same thing. They said there is no concluded contract. On appeal to Supreme Court, Supreme Court said that there is no denying the legal proposition that an arbitration agreement can be inferred even from exchange of letters, including communication through electronic means. The mere fact that it was not signed would not obviate from this principle. Obviate. Obviate. Obviate from this principle. The Supreme Court said, in this case, the conduct of the parties clearly manifested SGM's acceptance of terms and conditions, including arbitration agreement. The fact remains from the facts, Supreme Court said that 2000 metric tons of zinc was supplied. Invoices raised by GI contained the contract number. SGM complied with its obligations by furnishing standby letters of credit. Those letters of credit also contained the contract number. The exchange of correspondence also contains the contract number. The modification suggested by SGM was accepted by GI. Earlier we have seen that provisional price they did not accept. They said they needed some modification which was accepted by GI. The actions on the part of SGM clearly demonstrated due and complete acceptance of the contract. Therefore, it cannot bank upon its own failure to sign the contract and wriggle out of the terms and conditions. SGM said, no, I have not signed the contract. You cannot say, I did not sign the contract, so I will wriggle out of the terms and conditions. Further, the suit claim made by SGM was in pursuance of this contract, and there is no other contract or agreement between the parties. So Supreme Court said, you filed a suit for recovery of that amount. In that recovery of the suit, you filed the contract number. Other than that, there is no other contract. So that means what? That contract is already in existence. When an identical question arose before the Supreme Court, in the case of Govind Rubber Limited, wherein one of the parties had not signed the contract, Supreme Court held that an arbitration agreement, even though in writing, need not be signed by the parties if the record of the agreement is provided by exchange of letters, telex, telegrams, or other means of telecommunication. In the present day of e-commerce, in cases of internet or telepurchases, ticket booking on internet, and in the standard forms of contract, terms and conditions agreed upon in such agreements, if the identity of the parties are established and there is record of agreement, it becomes an arbitration agreement if there is an arbitration clause showing ad idem between the parties. ADIDEM, ad idem. It is not very material whether it is signed by the party or not. Supreme Court said Section 7(3) of ANC Act 1996 requires that arbitration agreement should be in writing. Section 7(4) gives 3 circumstances in which the arbitration agreement could be found. One circumstance is it must be signed. It did not mean that in all cases that arbitration agreement should be signed. This legal principle, this is very important. This legal principle will hold good for arbitration agreement covered by Section 44 and 45 of ANC Act 1996. That is the view of Supreme Court. Supreme Court set aside the order of division bench and directed that the parties shall be referred to arbitration in accordance with law. It again sent the matter back to division bench. That very interesting judgment. Thank you very much. Have a great and wonderful day.